We are looking at the operating system that makes those billion-dollar mega projects even possible in the first place.
Because without it, nothing gets built.
Right. We're talking about a document that dictates who pays when the ground literally collapses under your feet, or who is responsible when the highly complex technology fails.
And ultimately, who holds the bag when the budget completely blows up?
Exactly. We are unlocking the Silver Book.
Which I know sounds like a fantasy novel or a magical artifact when you say it like that.
It really does. Like something out of a video game.
But in the engineering and construction world, the Silver Book is about as real and as serious as it gets.
It is the script for the construction of the modern world. Specifically, we are diving into the FIDIC conditions of contract for EPC turnkey projects.
The second edition.
Right, the second edition, published back in 2017. And just to set the stage for you listening, what exactly does SIDI stand for?
It's the International Federation of Consulting Engineers.
Okay.
They're based in Geneva, Switzerland, and they essentially write the standard contracts that the entire global construction industry relies on.
They have a whole color-coded system, right?
Yeah, they have a whole rainbow of books, the red book, the yellow book, the green book, but the Silver Book is unique.
And it's unique because of that specific word on the cover, turnkey.
Exactly, EPC Turnkey, which stands for Engineering, Procurement, and Construction.
Let's actually unpack that before we even open the book and look at the clauses. Because to me, when I hear turnkey, I just think of buying a car.
Right, if you turn the key.
Yeah. I put the key in the ignition, turn it, and it drives.
Yeah.
I don't need to know how the engine was assembled or where the spark plugs came from.
That is precisely the psychology behind this specific contract.
Okay.
The Silver Book was created because employers, and by employers we mean the governments or the private developers with the funding, they wanted certainty above all else.
They don't want surprises.
No surprises at all. They wanted to be able to look a contractor in the eye and say, here's the exact price and here is the strict deadline.
You figure out the rest.
Basically, yes. You design it, you procure all the materials, you build the whole thing. And when you're completely done, I turn the key and the factory starts humming.
And whatever chaos happens in between is totally on you.
It is entirely your problem.
So if we really look at our sources for today, the entire mission of the Silver Book seems to be just a massive, almost brutal transfer of risk.
It is absolutely the most aggressive risk transfer in the standard FID suite. In the other contracts, like the Red Book, the risk is generally shared. It's balanced. But in the Silver Book, the contractor takes on almost everything.
Like what specifically?
The ground conditions, the freak weather events, the design errors. In exchange, though, they usually charge a significantly higher price.
So it's a risk premium.
Exactly. They are betting real money that they can manage the chaos better than the employer can.
They're backing themselves. All right, so today, our mission for this deep dive is to walk through the general conditions.
That's clauses 1 through 21.
Right. We want to see exactly how that high-stakes bet is structured. We're going to decode the legalese and find the underlying logic.
Sounds good.
So let's jump straight into segment 1, the setup and the players. This covers clauses 1, 2, and 3.
And it naturally starts with Clause 1, which is general provisions.
Right.
Now, I know people listening might be tempted to just kind of mentally fast forward through the definitions section of any legal document.
Oh, for sure. It's usually so dry.
It is dry, but in the Silver Book, skimming the definitions is fatal.
Yeah, our sources were very explicitly clear on this. Capitalization in this book is not just a stylistic choice. It's like a legal cage.
It really is. If a word is capitalized, it is a heavily defined term. And the classic trap in the 2017 edition, the one that catches experienced people out constantly, is the distinction between two specific terms.
Which ones?
Tests on completion and tests after completion.
I mean, I'll be honest, they sound like the exact same thing to me. Testing is testing right.
Not at all. Not in this world. Tests on completion with a capital T and a capital C are rigorously defined in Clause 1.1.75.
Okay, so what are they?
These are the mandatory hurdles the contractor must clear before the employer will even consider taking over the facility.
So if you don't pass those...
If you don't pass those, you are still on the clock. You are likely paying massive daily delay damages. You legally haven't finished the job.
Ouch. Okay, and then what about tests after completion?
Those happen much later. That's under Clause 12. That happens when the employer has already accepted the plant and is running it.
Oh, I see.
Yeah, they are usually about verifying the long-term efficiency or performance guarantees over time.
Mhm.
So if you mix those two up in an official letter or notice,
You're in trouble.
it can literally cost you millions in lost leverage.
Speaking of official letters, let's actually talk about Clause 1.3, the Notices Clause. Because reading the 2017 edition, it honestly seems to have a bit of an attitude problem here. It feels incredibly strict.
I wouldn't call it an attitude problem. I'd call it a clarity solution.
Fair enough.
The 2017 edition enforces a very rigid written or nothing culture on the site. Clause 1.3 essentially says point blank that if it isn't written down and formally issued as a DIRC, notice it basically didn't happen.
So the old romanticized days of the project manager shaking hands with the site foreman in the dirt and saying, hey, don't worry about that deadline, take an extra week, those days are gone.
Completely, absolutely gone. If you rely on that friendly handshake and you fail to issue a formal notice under Clause 1.3, confirming that verbal instruction, you will likely lose your right to claim that extra time later.
Because it protects against memory loss.
Exactly. Because 2 years later, when things have gone wrong and the lawyers are involved, nobody remembers the handshake. Everyone just reads the notices.
Right. If it's not on paper, it doesn't exist. Now, if the contractor's taking on all this immense risk, say they're building a billion-dollar oil refinery,
Right.
they obviously need some kind of safety net.
They do, and that is Clause 1.1 form, limitation of liability.
The ultimate shield.
The shield, yeah. Because the financial risks are so astronomical in turnkey megaprojects, the contractor generally negotiates a hard cap on their liability.
How does that work?
Well, Clause 1.14 usually states that the contractor's total liability to the employer shall not exceed a certain specific sum. Often it's capped at 100% of the contract price.
So if the project is a $500 million power plant, they cannot be sued for $600 million.
Exactly. The bleeding stops at $500 million.
But the sources also point out some pretty massive holes in that shield.
Oh, there are huge exceptions. The cap explicitly does not apply to cases of fraud.
Obviously.
Right. It also doesn't apply to gross negligence or, and this is a big one, to intellectual property infringement, which is covered under Clause 17.3.
Let's focus on gross negligence because that feels like a hidden trapdoor. The guidance notes in the source material specifically warned about this.
They really did. And here is why it's so dangerous. Gross negligence is actually not defined in the contract itself.
Wait, really?
Really, it is defined by the law of the country where the project is physically located.
Oh man, that is tricky.
Very. For example, in English law, proving gross negligence is notoriously difficult. It requires proving a serious, almost reckless disregard for risk.
You have to be acting wild.
Basically. But if you take a project in certain civil law jurisdictions, a simple structural calculation error, a mistake a junior engineer made could successfully be argued in local courts as gross negligence.
So just like that, if a local judge decides your mathematical mistake was gross, your entire liability cap just vanishes.
Correct. Poof, you could suddenly be on the hook for unlimited damages.
That is terrifying.
Which is exactly why defining these terms clearly in the particular conditions before you sign is so critical.
Let's pivot to the other side of the table for a second. Clause 2 covers the employer. Now, in a turnkey setup, I naturally tend to think of the employer as just the bank. They just sit back and write the checks.
A lot of employers think that too.
Right, but they have actual active duties, don't they?
They absolutely do. And if they fail them, the entire project can stall before it even starts. Clause 2.1 is right of access. It sounds incredibly simple. Give the contractor the land.
Just open the gate.
Open the gate. But on international megaprojects, land is never simple.
I can imagine.
I've personally seen projects where the contractor arrives with a fleet of expensive bulldozers and 500 workers, only to find out that the employer hasn't actually evicted the local squatters yet.
Oh, no.
Or the local government hasn't stamped the final land use permit. Clause 2.1 says the employer must give access by the specific date stated in the contract data.
And if they don't?
If they don't, the contractor sits there doing nothing, but they still get to claim an extension of time and their delay costs.
Because it's not their fault they can't start.
Exactly.
And then there's Clause 2.2, assistance. This is really interesting to me. It says the employer must actively help the contractor with permits.
Right, but there is a caveat. It says, if requested.
Ah.
Remember, this is a turnkey contract. The contractor is ultimately responsible for securing all those permits.
Yeah.
You cannot just sit back in your trailer and wait for the employer to hand you your work visas or your environmental clearances.
You have to do the legwork.
You do. But since the employer is usually the local entity with the established political connections and the local language skills, Clause 2.2 obligates them to use reasonable endeavors to assist.
So they can't just cross their arms and watch you drown in local bureaucracy.
Exactly. They have to help if you ask them to.
Okay, then we move to Clause 3, which is the employer's administration. And this introduces a very important character, the employer's representative. Who exactly is this person?
This person is essentially the conductor of the orchestra. They are appointed directly by the employer to run the day-to-day administration of the project.
So they are the boss on site.
Essentially, yes, they issue official instructions under Clause 3.4. But the real mechanism you need to fully understand here is Clause 3.5, agreement or determination.
This seemed like a highly structured, almost rigid process in the 2017 edition.
It's very structured. Whenever there is a disagreement on site, let's say an argument about whether a certain batch of concrete meets the specifications, the employer's representative cannot just snap their fingers and say, my way or the highway.
Even though they represent the employer.
Right. First, they have a strict contractual duty to consult with both parties. They have to sit them down and try to reach an amicable agreement.
They have to act as a mediator first.
The facilitator, yes.
And if they just absolutely can't agree,
then the representative steps in and makes a determination. And here is the real kicker of the 2017 Silver Book. It explicitly requires them to make this determination neutrally.
Neutrally. But wait, they're literally on the employer's payroll.
I know, that is the central tension of the entire role.
How does that even work?
It's difficult. When they are wearing their determination hat, they are legally supposed to be impartial interpreters of the contract. They are not supposed to be advocates for the boss who writes their paycheck.
That requires a lot of integrity.
It does. And if they fail to be neutral, if they clearly show bias, the contractor can reject the determination, treat it as a formal dispute, and escalate it to the dispute board. It's basically an attempt by FIDI to inject some fundamental fairness into what is otherwise a very one-sided turnkey contract.
That makes sense. All right, let's move on to segment 2. This is what I call the heavy lifting. This is Clause 4, the contractor. This section feels like the beating heart of the Silver Book because this is where that turnkey promise is actually put down on paper.
It really is the core of it all. In fact, Clause 4.1 contains arguably the most powerful phrase in the entire document.
Fit for purpose.
Fit for purpose.
Let's dissect that because it sounds simple, but it's huge.
It's massive. In a normal traditional construction contract, like say the FIDIC Red Book, the contractor generally just has to build exactly what is on the engineering drawings.
Right.
If the employer's architect draws a retaining wall that is far too thin and the wall collapses, the contractor just shrugs and says, hey, I built exactly what you drew. It's not my fault your design was bad.
But not here.
Not in the Silver Book.
Yeah.
Here, the contractor is the designer.
Right.
So Clause 4.1 says the completed works must be fit for the purpose that is defined in the employer's requirements.
So if I'm the employer, and my requirement is say I want a factory that produces exactly 1,000 widgets every single hour, and the contractor builds a beautiful, shiny, structurally perfect factory, but it only produces 500 widgets an hour.
The contractor is in total breach of contract.
Wow.
It doesn't matter if the concrete work is flawless. It doesn't matter if they work 24 hours a day for 3 years. The stated purpose was 1,000 widgets. If the plant doesn't do that, the contractor has to fix the design and rebuild it at their own cost.
That is the raw essence of turnkey. You are buying a specific result. You're not just buying a pile of bricks and pipes.
Precisely.
And that concept leads us directly into Clause 4.12. Unforeseeable difficulties. This is where the Silver Book really bears its teeth compared to the rest of the FIDI family.
Oh yeah, this is the famous ground risk clause.
Walk us through.
In almost all other FIDI books, if the contractor starts digging and they hit unexpected solid granite, or they uncover an underground river that wasn't on any survey, they can raise their hand and ask for more money and more time.
Because it's an unforeseeable physical condition.
Exactly. Nobody knew it was there.
But what happens in the Silver Book?
In the Silver Book, Clause 4.12 essentially looks at the contractor and says, you are the expert here. You should have investigated the site better. If the ground is harder than you thought, or if there's a massive hidden swamp, that's your problem.
So the contractor just eats the cost of the unknown.
Almost entirely yes.
Yeah.
Unless the employer provided geotechnical data that was practically impossible for the contractor to verify before bidding, the contractor owns the ground.
That's incredible.
And this is exactly why Silver Book prices are substantially higher. The contractor has to price in the sheer terror of the unknown.
They have to assume the worst-case scenario. Moving further through Clause 4, we get into the pure logistics of building a mega project. Clause 4.1c covers transport of goods.
Right. I mean, imagine trying to move a 300-ton gas turbine across a developing country with unpaved roads and weak infrastructure.
Sounds like a nightmare.
It is. And Clause 4.16 says the contractor is solely responsible for all of that, the packing, the loading, the shipping, the customs clearance.
And what if something goes wrong?
Well, specifically if their convoy of heavy transport trucks completely destroys a local bridge or ruins a public road on the way to the site, they have to fully indemnify the employer.
So you literally have to rebuild the public bridge you broke just trying to get to your job site.
Exactly. It's all on you.
Amazing. And then there's Clause 4.18, protection of the environment. This clearly isn't just a basic don't litter policy, is it?
No environmental liability has become a massive financial risk. Clause 4.18 explicitly requires the contractor to ensure that emissions, surface discharges, and any effluent do not exceed the strict values stated in the employer's requirements or the local laws.
So if an excavator leaks hydraulic fluid or someone spills diesel into a local river?
The environmental cleanup costs and the massive government fines are entirely on the contractor. The employer just completely washes their hands of the incident.
Then there's Clause 4.21, security of the site.
You have to picture the scale of these projects.
Yeah.
You might have 5,000 workers on site. You have miles of highly valuable copper wire. You might have explosive materials for blasting. You have machinery worth millions.
It's basically a small city.
It is. And Clause 4.21 mandates that the contractor is solely responsible for keeping unauthorized people out and keeping authorized people safe inside.
Which in some regions is not easy.
No, in certain volatile regions, this involves building massive concrete perimeter fences, hiring private armed security forces, and running strict biometric access control protocols, all at the contractor's expense.
Before we wrap up Clause 4, let's talk about subcontractors. That's Clause 4.4, because obviously no main contractor can do absolutely everything themselves. They have to hire specialized electricians, plumbers, steel fixers.
They do, but the Silver Book is uncompromising here. The main contractor is the single absolute point of responsibility.
No pointing fingers.
None. Clause 4.4 states unequivocally that the contractor is legally responsible for the acts or defaults of any subcontractor exactly as if they were the contractor's own acts.
So you cannot go to the employer and say, oh, I'm so sorry, the project is a month late. My electrical sub was just really slow.
The employer does not care. To the employer, your subcontractor legally doesn't even exist.
What about nominated subcontractors? That's in Clause 4.5, like where the employer explicitly says, hey, you must use this specific local company to install the elevators.
That's a great point. Even in that specific scenario, the Silver Book places the ultimate burden on the contractor.
How is that fair if the employer chose them?
Well, if the employer nominates someone, the contractor has a strict window to raise a formal objection if they have proof that the nominated subcontractor is technically incompetent or financially underfunded.
And if they don't object?
If the contractor stays quiet and doesn't object, they legally accept the risk of that subcontractor's performance. It is just incredibly hard to shift blame in this contract.
It really is an ironclad cage. Okay, let's move to segment 3, the brains and the hands, Clauses 5 and 6. Clause 5 is all about design.
Which heavily reinforces what we discussed in Clause 4.1 about fit for purpose. Clause 5.1 explicitly states in plain language the contractor shall carry out and be responsible for the entire design of the works.
But here's the classic scenario that always confuses me. The contractor drafts the blueprints. They submit the design. The employer's team reviews it for a month and finally stamps it, approved in big red letters.
Right.
A year later, the roof literally caves in because of a fundamental design error. Can the contractor turn around and say, hey, you looked at it and you approved it?
No, absolutely not.
Right.
Clause 5.8 covers design error. It explicitly says that any review or approval by the employer does not relieve the contractor of their ultimate responsibility.
Wow.
Yeah, the employer is essentially saying, well, it looks okay to my guys, but you are the high-paid turnkey expert. If it fails, it's still your fault.
The source material also included a really fascinating advisory note about BIM, Building Information Modeling. This feels like the digital frontier violently colliding with the legal world.
It's exactly that. FIDIC recognized that in the 2017 edition because we aren't just drawing lines on flat paper anymore.
Right, we're building these incredible 3D digital twins.
Exactly. So the advisory notes warn users that if your project is using BIM, you have to carefully amend the definitions of words like design and drawings in the particular conditions.
Because a drawing isn't just a PDF anymore.
Right. A contractor's document might actually be a massive, complex, cloud-hosted database. So the contract needs to legally address new risks. Who owns that data? Who has access rights? What happens to the project schedule if the cloud server crashes for a week?
That's a whole new layer of risk. Speaking of vital documents, clauses 5.6 and 5.7 cover as-built records and operation and maintenance manuals.
Yes. These are historically the most neglected, delayed part of any job, but they are absolutely vital.
What are as-builts exactly? Clause 5.6.
As-built records are the final drawings that show how the facility was actually built in reality, which almost always differs from the initial pristine plan because of field changes.
Right, you had to move a pipe because a rock was in the way.
Exactly. And then Clause 5.7 covers the O&M manuals.
The instruction manual for the factory.
Exactly. And Clause 5.7 gives the employer a massive hammer. It says the employer literally does not have to take over the project until these manuals are detailed enough for their staff to actually operate, maintain, dismantle, and repair the plant.
So you could build a 100% perfect billion-dollar power plant.
Yeah.
But if you don't hand over the binders explaining how to properly change the oil in the turbines, you don't get paid your final milestone.
Correct. Because without those specific manuals, the entire turnkey concept completely fails. The employer can't operate the asset they just bought.
That makes total sense. Now let's look at Clause 6, staff and labor. I have to say, reading this section felt surprisingly human for such a dense, highly technical document. It's not just about hiring engineers, it's about how you treat the workforce.
It really covers the human element of mega projects. Clause 6.7 talks about health and safety. The contractor legally must appoint a dedicated accident prevention officer. They have to formally send details of any and all accidents to the employer.
And Clause 6.6 mentions facilities for staff and labor.
Yes. It goes beyond just building a bunkhouse. It explicitly mentions providing an adequate supply of potable water. And interestingly, it demands protection against insect and pest nuisance.
Insect nuisance. That is literally written into an international contract.
It is. Think about it. If you are building a massive hydroelectric dam deep in a tropical jungle region, an outbreak of malaria or dengue fever can literally wipe out your entire workforce in a week.
Oh, wow. I didn't think of that.
Yeah, Clause 6.6 makes it a strict contractual obligation to aggressively manage site drainage and pest control. It sounds like a small detail, but if your workforce gets critically sick, the whole billion-dollar project grinds to a halt.
And what about Clause 6.11, disorderly conduct?
Well, again, you have a temporary city of thousands of young men usually living away from home. The contractor is completely responsible for their behavior. If workers are drunk fighting or engaging in criminal activity, the employer can formally order them removed from the site permanently.
Maintaining law and order, basically.
Exactly.
All right, let's march on to segment 4. Execution and time. This covers clauses 7 and 8. Clause 7 is plant materials and workmanship. I view this as the ultimate quality control section.
This is where the rubber really meets the road in terms of quality. Clause 7.3 gives the employer a very powerful right. They can inspect the manufacture of materials off-site.
Off-site. So if I'm the employer building in, say, South America, I can fly my inspectors to a factory in Germany to check the turbines before they even go on a ship.
You absolutely can. You can walk the production line in Germany. And if you find something wrong under Clause 7.5, you can issue a formal rejection right there.
You don't have to wait for it to arrive.
No, you don't have to wait for the defective parts to travel across the ocean, arrive on site, and be installed. You can say, that is not what we ordered. Fix it or replace it right now in the factory.
That saves everyone so much time. There's also an interesting legal point in Clause 7.7 about ownership. When does a massive pile of structural steel sitting in the dirt actually become the employer's property?
That's a critical question. Usually under the standard text, it becomes the employer's property when it is physically delivered to the site. However, it can also transfer earlier if the contractor has already been paid for it.
Why does that matter so much?
It is absolutely crucial for bankruptcy protection. If the contractor suddenly goes bust and files for bankruptcy halfway through the project, the employer wants to be able to walk onto the site, point to those million-dollar steel beams, and tell the liquidators, those are mine, I paid for them, nobody else can take them.
Right, protecting the investment. Now we get to Clause 8. This is the one that probably keeps project managers awake at night sweating. Commencement delays and suspension.
Oh, yeah. Clause 8.2 is time for completion. The project has a firm, hard deadline. It is stated plainly in the contract data. The entire operational life of the contract revolves around hitting this date.
But we know the real world. Dates slip, things happen, supply chains break. So we have Clause 8.5, extension of time,
Right.
or EOT.
This is the primary battleground of construction law.
Yes.
The contractor can only get an EOT if the critical delay is caused by very specific listed things, like a variation ordered by the employer, or a cause of delay giving an explicit entitlement under another subclause, like if the employer failed to give site access on time.
Right.
Or, and this is the deeply controversial one, exceptionally adverse climatic conditions.
Exceptionally adverse. So just having a week of really bad weather doesn't count.
Absolutely not. In the Silver Book, normal bad weather is entirely the contractor's risk.
Okay.
If you are building a project in Scotland, you expect a lot of rain. If you're building in Dubai, you expect extreme heat. You price that in. To get an EOT, the weather has to be truly exceptional for that specific location in that specific time of year.
Like a 1-in-100-year freak storm.
Exactly. Only then do you qualify for an extension.
And if they don't get that EOT approved and they are late, we slam right into Clause 8.8, delay damages.
Often referred to in the industry as liquidated damages, or LDs. It is usually a very large fixed amount of money assessed for every single day of delay.
Like what kind of money?
Say $100,000 for every day the power plant is late.
Just evaporating from their profit every morning.
Mhm.
Is that legally considered a punishment?
That's a great legal question. Technically, no.
How?
In most jurisdictions, common law, especially purely punitive penalties in contracts, are actually unenforceable.
Oh, really?
Yeah. So this has to be calculated as a genuine pre-estimate of loss.
I see.
It mathematically represents the actual revenue the employer is losing because the plant isn't running and selling electricity yet. It caps the contractor's liability for being late, but it also ensures they feel immense daily pain if they miss the deadline.
And finally, in this section, we have suspension, Clause 8.9.
The employer has the right to pause the work. They can just yell, "Stop everything."
And if they do that,
If they do, they generally have to pay the contractor for all the idle time, the rental costs of the equipment just sitting there, and the cost of protecting the partially built works.
makes sense.
But interestingly, under a different clause, Clause 16.1, the contractor also has a right to suspend work, but usually only if the employer fails to pay them.
So it's basically a contractual strike.
Exactly. No pay, no work. It is by far the contractor's strongest immediate leverage.
Okay, we are officially halfway through the book. Take a breath. We're moving to segment 5. The testing gauntlet. This spans clauses 9, 10, 11, and 12.
Yeah.
Honestly, reading this felt like the final boss fight of a really hard video game.
It really is a gauntlet, and it kicks off with Clause 9, which is tests on completion. We are back to those heavily defined terms.
So set the scene. The contractor has laid the last brick, and they say, okay, I'm done. Let's test this thing.
Right. So under Clause 9.1, the contractor gives formal notice that they are ready. Then they have to run the grueling battery of tests that are specified in the employer's requirements.
What are they looking for?
These tests are designed to comprehensively prove the facility is structurally safe and mechanically functional before anyone takes it over.
And what if they fail? Let's look at Clause 9.4.
The employer has a few options. First, and most common, they can simply order the contractor to fix the issue and repeat the tests.
At the contractor's expense.
Of course. But if they fail again and again, the employer can invoke the nuclear option. They can reject the works entirely.
Reject the whole billion-dollar thing. Just say no thanks.
Yes. They can say, take it away, dismantle it, give me my money back.
That is wild. Does that actually happen?
Rarely, because it's a disaster for everyone.
Yeah.
More commonly, they might choose an alternative route. They might agree to accept the defective underperforming plant, but they will heavily penalize the price.
Like a discount.
Exactly. If the contract demanded a facility that produces 100 megawatts and your plant maxes out at 90, the employer might say, fine, I'll take it, but I am cutting the final payment by 10%.
Right. Once those tests on completion are finally passed, we reach the Holy Grail. Clause 10. Employers taking over.
The taking over certificate, the TOC, this is the absolute pivotal moment in the entire project timeline.
Why is it so important?
Because once the certificate is formally issued, 3 massive things happen instantly. Number 1, the contractor is officially no longer liable for any further delay damages. The clock stops.
Huge relief.
Number 2, The legal responsibility for caring for and ensuring the works completely passes from the contractor to the employer.
Okay.
And number 3, usually a large chunk, often half of the retention money that the employer has been holding back, is finally released to the contractor as cash.
It's graduation day, basically.
Uh-huh.
But wait, there's a fascinating twist in Clause 10.3. It talks about interference. What if the employer deliberately prevents the testing from happening? Like maybe they aren't administratively ready to take over, or they just don't want to make that massive final payment yet.
That is a brilliant protection mechanism. If the employer unjustly prevents the test from occurring for more than 14 days, or if they actually just start using the facility to generate commercial revenue before the tests are even done.
Which happens, right?
It happens. In those cases, the contractor can claim that the works are deemed to have been taken over.
Deemed. I absolutely love that legal word. It basically means we are legally pretending this happened, even if you stubbornly refuse to sign the actual piece of paper.
That's exactly what it means. You cannot drive the car off the lot, use it for a month, and then refuse to sign the delivery receipt saying you haven't accepted it yet.
Okay, so the employer finally takes the keys. They are running the plant. But the contractor isn't completely off the hook yet, are they? Enter Clause 11, defects after taking over.
Right. The DNP, the defects notification period.
How long is that usually?
Usually it's 1 or 2 full years. During this time, the contractor is essentially on an active warranty. If a door handle falls off, or a massive high-pressure pump starts leaking, or the exterior paint prematurely peels, the contractor has to mobilize and come back to fix it under Clause 11.1.
At their own cost again.
At their own cost. And then we hit the confusingly named Clause 12, tests after completion. Right.
Remember the crucial difference. The plant is now fully running. The employer is commercially operating it. Clause 12 covers performance tests that can realistically only be done under actual real-world conditions over a long, sustained period.
Give me an example of that.
For example, a test might be, does this massive new desalination plant actually produce clean drinking water reliably for 30 days straight without the filters clogging and the system overheating?
You can't test that in a single afternoon before handover.
Exactly.
And if it fails, this is Clause 12 test.
Then you face non-performance damages under Clause 12.4.
Which means?
If the plant fundamentally runs, but it burns way too much fuel to do it, or it produces slightly too little output, the contractor has to pay the financial difference in value. It's an administrative way of mathematically adjusting the final contract price based on the actual true quality of the operating asset.
It sounds totally brutal, just constant, relentless testing. That is the fundamental nature of performance-based turnkey contracting. You aren't just buying bricks and mortar, you are buying a guaranteed economic result.
Let's move to Segment 6, Money Changes and Termination, Clauses 13 through 16. We start with Clause 13, which is variations.
This is basically the employer's right to change their mind midstream. Clause 13.1 says the employer can instruct a variation at any time before the taking over certificate is issued.
Like what kind of changes?
They might say, hey, add an entire new wing to the administration building, or we changed our mind, swap out that brand of turbine for this larger model.
But the contractor gets paid extra for that, surely. It's not free work.
Yes, they get paid. But they have to meticulously follow the procedural rules. They usually have to submit a detailed technical and financial proposal. The employer reviews and approves it, and the contract price is formally adjusted.
Can a contractor ever say no? Like, I don't want to build a new wing.
In a normal contract, no. But in the Silver Book, the contractor does have a limited right to formally object.
On what grounds?
If the proposed variation would fundamentally lower the safety of the works, or if the contractor simply cannot procure the specific obscure materials required, they can refuse to execute the variation.
Interesting. Now, Clause 13.7 mentions adjustments for changes in costs. This is basically just dealing with inflation, right?
Yes. If the global cost of raw steel or local labor suddenly skyrockets by 40% during the 3-year project, who absorbs that hit?
I'm guessing the contractor.
Usually, yes. In the Silver Book, often the specific clause is entirely struck out or not utilized by the employer. The overarching philosophy is that the contractor should meticulously price in the long-term risk of inflation when they submit their fixed turnkey bid.
But the standard printed text allows for it.
The standard text does allow for it, but only if both parties proactively agree on a complex mathematical table of adjustment data before signing.
All right, let's talk pure cash flow. Clause 14 is contract price and payment. How does the money actually flow from the employer's bank to the contractor?
It generally happens in three main stages. It starts with an advance payment under Clause 14.2.
How much is that?
Usually 10 to 15% of the total price. This is crucial cash to get the contractor mobilized to buy the initial heavy equipment and set up the site camp.
Okay, and then?
Then it's interim payments under Clause 14.3. Every single month, the contractor submits a massive detailed statement basically saying, I have completed X amount of work this month.
The employer's representative reviews it.
Verifies it, signs a payment certificate, and the employer pays that monthly chunk.
In the end.
Finally, a final payment under 14.13. This only happens years later after the entire defects notification period is over, all the tiny snags are fixed, and the final discharge is legally signed.
Okay, now we have to talk about the dark side, the messy breakups.
Yeah.
Termination. Clause 15 is when the employer ends it, and Clause 16 is when the contractor ends it.
Let's look at the employer first. Clause 15.2 lists all the dramatic reasons the employer can outright fire the contractor.
Like what?
Abandoning the worksite entirely, flagrantly failing to comply with formal notices, going bankrupt. Or the catch-all, plainly demonstrating the intention not to continue performance.
Basically just giving up. But there's also Clause 15.5, which I found staggering. Termination for employer's convenience.
Oh, this is an incredibly powerful unilateral right. The employer can basically wake up one morning and say, you know what, I just don't want a power plant anymore, go home.
They don't even need a reason.
They don't need to justify it. Global oil prices might have dropped, making the project unviable, or a new government got elected and political priorities suddenly changed. They can just pull the plug.
That sounds insanely dangerous for the contractor.
Yeah.
Do they at least get paid out for the whole job?
They get paid for the actual work they've completed up to that day, and they get reimbursed for materials they've already irreversibly ordered.
But what about the profit they were expecting?
Critically, under the standard unamended FIDA wording in the Silver Book, they generally do not get paid for the anticipated loss of profit on the uncompleted rest of the job. Yeah, they just get their sunk costs covered and they have to pack up and walk away. It's a massive commercial disappointment, but mathematically it shouldn't be a total financial disaster, hopefully.
And what about Clause 16? When can the turnkey contractor say enough is enough and walk away?
Principally, it's about the money. If they do not get paid, if the employer is chronically late issuing a payment certificate, or if the employer completely fails to provide evidence of their financial funding arrangements.
What's the process?
Clause 16.1 allows them to suspend work first, give them a warning, and if the money still doesn't come, 16.2 allows them to fully terminate the contract.
And if the contractor terminates because the employer is essentially being a bad actor and defaulting?
Then the tables turn. In that scenario, the contractor does get paid for their loss of profit under Clause 16.4.
Okay, that's fair.
Because the employer actively breached the contract, they have to fully legally compensate the contractor for the money they would have legitimately made.
Make them whole. All right, segment 7. Risk insurance and force majeure. Clauses 17, 18, and 19. Clause 17 specifically talks about care of the works.
Right. This legally answers a very simple but terrifying question. If the half-built building gets struck by lightning and burns to the ground the night before completion, whose problem is it?
I'm going to guess the contractor.
You'd be right. The contractor's problem. Clause 17.1 states that the contractor takes full total responsibility for the physical care of the works from the commencement date all the way until the taking over certificate is issued.
Clause 17 also deals heavily with indemnities. We saw this legal word a lot in the sources.
An indemnity is essentially a legally binding promise to pay and shield someone else. Clause 17.4 says the contractor formally indemnifies the employer against claims for bodily injury or third-party property damage caused by the contractor's operations.
Give me a real-world example.
Sure. If the contractor's heavy crane collapses and falls onto a passing civilian car on the highway outside the site, the contractor pays all the damages, all the legal fees, and legally keeps the employer completely out of the lawsuit.
Then we have Clause 18, exceptional events, which I learned used to be called force majeure in the older editions.
Yes. FIDA deliberately updated the terminology in 2017 to be more precise and plain English.
What counts as an exceptional event?
It has to be something truly beyond human control. War, armed rebellion, violent riots, or massive natural catastrophes like unprecedented earthquakes or Category 5
The
hurricanes.
source index also highlights a duty to minimize delay in Clause 18.3.
That is a key modern addition. Even if there is a massive earthquake, you cannot just sit back in your chair, throw your hands up, and yell force majeure.
You have to try and work.
You have a strict duty to minimize the impact. If you can still safely work on the east side of the site while the west side is damaged, you must keep working.
And what if it lasts forever?
If an exceptional event entirely prevents the work for a long, sustained period, usually 84 continuous days, then either party can officially terminate the contract without penalty.
And wrapping up this segment, Clause 19 is insurance.
This is the ultimate financial backstop. It legally requires comprehensive insurance policies for the works themselves, for the heavy equipment, for liability to third parties, and crucially, for workers' compensation.
Checks that.
The contractor typically has to physically hand over the valid insurance certificates to the employer before they are even allowed to start digging the first hole. It guarantees that if something catastrophic goes wrong, there is a very large pile of liquid money available to fix it.
All right, we are in the home stretch, Segment 8. When all else fails the disputes, Clauses 20 and 21.
Let's start with Clause 20, which is claims. This is the mandatory administrative step. If the contractor feels they deserve more money or an extension of time, they cannot just complain, they must submit a formal claim.
And knowing the 2017 edition, I'm assuming it's very strict here too.
It is incredibly strict. Clause 20.2 sets a vicious time bar. You must give formal notice of a claim within exactly 28 days and becoming aware of the event that caused it.
What if you were 29 days late? Like you just missed it by a day?
If you are 29 days late, the employer is totally, completely discharged from all liability.
Wow.
You get absolutely nothing. It is a legal guillotine.
That seems hellish. Why is it so rigid?
The commercial logic is that the employer needs to know about very expensive problems immediately so they can investigate while the evidence is fresh. They absolutely do not want to receive a surprise claim for $5 million at the very end of a 4-year project for some muddy trench that collapsed 3 years ago.
That makes a lot of sense, actually. But what if the contractor submits the claim on time and the employer just outright rejects it? Then we go to Clause 21, disputes and arbitration. And here is where our sources say the 2017 edition made a really huge progressive change with something called the DAAB.
Yes, the Dispute Avoidance and Adjudication Board. In the older 1999 books, it was just a DAB, a Dispute Adjudication Board. They explicitly added the word avoidance.
What's the practical on-the-ground difference?
The DAB is a panel of independent experts appointed at the very start of the project, not just a panic button you hit when a massive fight breaks out.
So they are involved from day one.
Yes, they physically visit the site regularly under Clause 21.1, usually every 3 or 4 months. They get to know the people. And Clause 21.3 specifically empowers them to provide informal assistance to help the parties actively avoid a dispute.
So they act almost like project counselors or therapists.
Basically exactly that. They can walk the site, see the contractor's manager and the employer's rep aggressively arguing over a retaining wall design and say, look, guys, before you write nasty letters and get the expensive lawyers involved, here is our informal expert view on how you should technically solve this today.
They try to put out the fire while it is still just a spark.
Exactly.
That sounds so much healthier and cheaper than going straight to court.
It is exponentially better. But of course, if avoidance ultimately fails, they put on their judge robes and act as adjudicators. They issue a formal written decision under 21.4.
And do you have to listen to them?
Yes. Here is the true power of it. Clause 21.7 says failure to comply. The DAB's written decision is legally binding immediately.
So you have to do what they say right then.
You absolutely have to follow it, even if you fiercely disagree and you plan to appeal it to full arbitration years later. The rule is you comply now and you argue about it later. Keep the project moving.
And if you just absolutely cannot accept their decision?
Then your final destination is arbitration under Clause 21.6. Usually conducted under the ICC rules, held in a neutral city like London or Paris with a panel of extremely expensive arbitrators.
Which nobody wants.
Nobody. Arbitration is incredibly slow, it costs millions in legal fees, and it completely destroys whatever is left of the commercial relationship. The entire structural point of the Silver Book's clauses 20 and 21 is to build a fortress to keep you out of arbitration.
Keep the lawyers away. So we've literally walked through all 21 clauses of the general conditions. It is an absolute beast of a document.
It is a brilliantly designed, highly complex, comprehensive risk allocation machine.
Let's try to summarize it all for the listener.
Yeah.
The core Silver Book turnkey philosophy. The contractor essentially says, I will give you a fully functional working facility for a completely fixed price by a hard fixed date, and I will swallow almost all the terror and risk of getting there.
And the employer says, in return, I will pay you a massive financial premium for that peace of mind.
Right.
Correct. Certainty of price and certainty of time is the ultimate goal. But as we've seen, achieving that certainty requires strict, ruthless adherence to the rules, the definitions, the notices, the rigid testing procedures.
Right.
You simply cannot use the Silver Book casually or sloppily.
It will crush you if you do. And that actually leads me to my final thought for this deep dive. The source material talks a lot about the golden principles of SIDA. The idea of keeping the delicate structural balance of the contract totally intact.
Right.
But I'm looking at this and thinking, despite this theoretically perfect 21-clause structure, despite the clever avoidance boards and the strict notices, billion-dollar mega projects still constantly end up violently blowing apart and going to court.
It's the great paradox of construction law.
So why? I want to leave the listener with this. Is it the contract that is failing, or is it the people using it?
I personally think the contract fundamentally assumes rational actors operating with perfect information.
Which doesn't exist.
Exactly. In the messy real world, contractors intentionally underbid just to win the job, desperately hoping to find clever legal loopholes later to make up their margin.
And employers.
Employers completely change their minds halfway through, but then stubbornly refuse to pay for the variations they caused. Ultimately, no amount of perfect ink on expensive paper can fix a toxic relationship where one side fundamentally feels cheated by the other.
That is the ultimate takeaway right there.
Oh.
The Silver Book is a brilliant, flawless map, but at the end of the day, you still have to drive the car through the mud.
And you definitely have to read the manual before you start the engine.
Absolutely. So for all of you listening who are currently involved in turnkey projects or writing contracts, go open your desk drawer right now and check your definitions.
Seriously.
Go read clause 1.1.75 again. Are you legally testing on completion or after completion? Finding out you're wrong right now might literally save your company $1 million tomorrow.
And please, whatever you do, just write your notices. Follow clause 1.3. Don't rely on a handshake.
Wise words. Thanks for joining us on this incredibly deep dive into the FEI Silver Book and the invisible rules that build our world. We'll catch you on the next project.
If you're interested in the templates, please visit our shop. The link is in the description.
Thanks for watching. Please subscribe and see next time.